Okay, good morning everybody. Good morning. You're very welcome to the Outdoor Recreation Northern Ireland training webinar. This one, as you know, is on access legislation in Northern Ireland. My name is Chris Scott. I'm the Head of Operations with Outdoor Recreation Northern Ireland, and I'll be your MC for this session. I'm going to move on to the next slide there, please. So it's great to have nearly 100 delegates registered for this webinar. I can see you're all slowly getting your way logged online at the moment, which is great. Many moving parts in these webinars, our broadband, your broadband, etc., etc. So we'll give a few moments for folk to get online before we crack on with the first presentation. For those of you who don't know us, although from looking at the delegate list, it's great to recognise so many familiar names across government departments, arm's length bodies, councils, ENGOs, national government bodies, funders, community groups. So it's great to see the range of people that have engaged with this webinar. It shows the range of people that are engaged with the recreation sector, and also, you know, the impact that access legislation has across the sector as well. So, but for those of you who don't know us, we're Outdoor Recreation Northern Ireland. We're a not-for-profit organisation, and we make it easier for people to responsibly enjoy the outdoors. We do that via a number of ways. This being one, that delivering training sessions and sharing good practice. We also champion the outdoors through advocacy and various lobbying activities. We plan and develop quality outdoor recreation experiences. We increase awareness through things like our consumer websites like walkni.com, mountainbikeni.com, outmoreni.com, etc. And we widen, increase and sustain outdoor recreation participation as well. The next slide then will show us just an overview of some of the activities and endeavours we get up to over the years. So some projects we put on the ground, best practice training, etc. So if you just move on to the next slide there, please. So just in terms of today, we've got a busy schedule over the first hour or so, and then we'll move on to breakout rooms. More on that later. So in terms of the running order today, first of all, Carolyn Ferris, who's the Executive Director of ORNI, is going to give an overview of current access legislation. Then Mark Strong, who's from the Coast and Countryside team in Causeway Coast and Glens Borough Council, is going to give us an overview of asserting public rights of way. I'm then going to give a case study example of permissive path agreements with regards to the Culca to Cleanish project that we're leading down in County Fermanagh. And then Graham Seymour, who is chair of the National Outdoor Recreation Forum, is also joining us to talk about what a new outdoor recreation bill for Northern Ireland might look like. This webinar is quite timely. As many of you in the sector will know, DARA have been, undertaking a review of current access legislation. We understand that a public consultation on such will be issued imminently. So it's good to take stock of the current position and maybe discuss some ideas looking forward. So we obviously, as a sector, welcome that opportunity to contribute to the review. We'll then move to breakout rooms, as I said, and we'll provide more information of that as we get to the close. Just to remind you that this webinar is being recorded, so you can sit back and relax and take in the information without having to worry about scribbling furiously on notes. You'll be provided all the videos and all the slide decks, etc. Via eZine tomorrow. They'll be available via our YouTube channel and via the Outdoor Recreation NI Hub. So sit back, relax and enjoy and take it in rather than having to worry about scribbling with notes, etc. I would say again, some presenters have pre-recorded their presentation, and then Graham will be joining us live. So again, we're not Hollywood. Some of the sound quality may vary according to the broadband strength and signal from the presenter's house in the this times that we're in. So be ready on your volume button on your laptop or device. You may have to turn it up or down as you go through this webinar. So you'll work with us on that one, I'm sure. So I think that's covered everything, and I think it's great to see people coming online there as I've been talking. So we've got a good bunch ready to go. We're going to queue up the first presentation slide then, which is sort of an overview, and that's going to come from Carolyn. I would remind you that there is an opportunity to engage with us during this stage via the question panel. So you'll see in the top corner of your screen an opportunity to ask questions. We may answer some of those during the webinar. Obviously, there's experts in the delegates for this webinar as well. So if somebody asks a question and you think you know the answer or you want to contribute to the debate, please jump on and do that as well. Those who are chairing the breakout rooms later will obviously be taking notes of the questions, and we can maybe use some of those to reflect on during those breakout rooms. So please do ask questions in the breakout pane as we go through, and we'll queue up Carolyn's presentation now and get moving forward with the presentations. Thanks.
Thanks, Chris, and good morning to everyone. So I have the challenge over the next 15 minutes or so to try and give you an overview of Northern Ireland's current access legislation before handing over to Mark and to Chris, who will then demonstrate how the theory translates at a practical level on the ground. But before I get stuck into the legislation side of things, I want to share with you one slide that I think sets the scene really well in terms of just how important the topic of access is right now in Northern Ireland. Back in April, during the first COVID lockdown, we thought we would try and hard evidence the impact and the value of local trails and green space to people's lives during the pandemic. So we used an online survey approach to interview, and just under 1,500 responses were received. So what have we learned from it? Well, there is an unprecedented rise in the use of the outdoors during lockdown. Nearly half the population spent more of their free time outdoors than they did this time last year, and over half expect to spend more free time outdoors moving forward. We've always known that getting into the outdoors was good for people, particularly in terms of health and well-being, social inclusion, community cohesion, economic development, and environmental awareness. And so we were able to confirm our thinking through the survey on this. You can see 84% felt physically healthier and fitter. 89% reported that they felt calm, relaxed, refreshed and revitalized. And 79% felt closer to nature. Conversely, the research also highlighted barriers to people getting outdoors. And in particular, that included deprivation and not having safe places to walk. Half of the population of Northern Ireland don't have off-road walking trails within easy distance of their home. Consequently, they visit the outdoors less. We also found the correlation between the lack of off-road trails and the most deprived areas and rural areas in Northern Ireland. So having to walk on roads and roadside pavement poses a safety issue and a major stumbling block to sustaining or growing participation over the long term. So what does this mean for us all? Well, it means that with increased numbers using the countryside, we need to be working to secure additional access opportunities across Northern Ireland and managing effectively those areas already open to access. Before I come on to Northern Ireland, I think it's just worth taking a few minutes to do a brief comparison with the situation across in Great Britain. It's true to say that Northern Ireland does not provide the same level of access as they do in other parts of the UK. In Scotland, under the Land Reform Act of 2003, there is a freedom to roam and a right of responsible access. Whereas in England and Wales, the 2000 Crow Act gives public access to land mapped as open country, which is mountain, moor, heath and down, any land above 600 metres above sea level where no map exists, registered common land, and land designated by the owner as access land. Then, more recently in England and Wales, the Marine Coastal Access Act has opened up a coastal route around England and Wales, all of which leads to greater levels of public access to land. Within Northern Ireland, access is provided by both public and private landowners, but by far the majority of our access is provided by public landowners. In 2010, Forest Service NI introduced a new Forestry Act, which gives the public a statutory right of access to all of its forests by foot. Under the 2006 Water and Sewerage Service Order, Northern Ireland Water is obliged to have regard to the desirability of public access to its land. And DERA, under the Conservation and Amenity Lands Order 1985, can designate lands as national parks or areas of outstanding natural beauty, including promotion of public enjoyment of the area and the provision and maintenance of public access. They can also create nature reserves, many of which are open for public access. And finally, they can also acquire land for access provision under the 1985 order. In terms of access to private land, the key piece of legislation governing access to the countryside in Northern Ireland is the Access to the Countryside Order 1983. The order designates the councils as the guarantors and the facilitators of access, and it's designed to facilitate both linear access and access to open country. The legislation gives councils powers to enter into public path creation agreements with landowners to create public rights along linear routes. It also gives them powers to designate new open access areas in areas of open country for open air recreation. It allows them to acquire areas of open country for the provision of access. And for both orders and agreements, compensation can be made to the landowners concerned. So, for example, if the value of a landowner's land depreciates as a result of an access order, they are entitled to compensation. So Part 2 of the 1983 order states that council shall assert, protect and keep open and free from obstruction any public right-of-way. So what is a public right-of-way? Well, a public right-of-way is a highway which any member of the public can use as a right. It is not a privilege granted by the landowner. It may be created specifically by the landowner, or it can be created through deemed dedication. That's essentially where a landowner knows a path has been used by walkers over a period of time. It can be limited to certain uses, so there are three types of public rights-of-way. It can be a footpath for walkers only, a bridleway for walkers and horse riders, or a carriageway for walkers, cyclists, horse riders, horse-drawn vehicles and motor vehicles. It is a legal entity and it will remain a legal entity until the path is extinguished or diverted by due legal process. Public rights-of-way must be respected by the occupier and the landowner. The duty of care on the landowner is limited with a public right-of-way. And just to give some comparison between how we're doing in Northern Ireland versus across the water, well, there was 123 miles of public rights-of-way in Northern Ireland a few years ago, compared to 118,000 miles of public rights-of-way in England. So in reality, councils across Northern Ireland really show little enthusiasm for discharging their duties under the 83 Access Order, and even less for exercising their discretionary powers. In reality, most access to the countryside in Northern Ireland is secure through other pieces of legislation, the most important being the Education and Youth Service Order 1986. This order requires councils to ensure that there are adequate facilities for recreational, social, physical and cultural activities within their area, and councils often use it to secure permissive access. That is access that has the permission of the landowner. So councils can enter into what is called permissive path agreements with landowners. A permissive path is not a public right-of-way. It is when landowners allow access for walking, cycling or horse riding. It is the creation of linear access on any terms agreed by the council and the landowner. Permissive path agreements are usually for a defined period, so they could be for, say, 10, 21 or 25 years. They can be closed at certain times of the year, for example, to protect bird nesting sites. Everything is agreed between the landowner and the council at the time of creating the permissive path agreement. Under permissive path agreements, the council then usually takes on the management, maintenance and liability of the permissive path. So coming on to a duty of care for recreational users. One of the greatest barriers still in Northern Ireland to securing additional access revolves around the whole issue of occupiers' liability and the perception out there within the landowning community that by inviting someone to walk across your land, you're increasing your liability, you're increasing your risk. Any occupier of land has a duty of care to people who come onto it, whether they're a recreational user or not. The level of responsibility is determined by both the 57 Occupiers Liability Act, which governs an occupier's duty of care to a visitor, and the 87 Occupiers Liability Act, which determines whether a duty of care is owed towards non-visitors, i.e. trespassers. So users of permissive paths are visitors. Therefore, the duty of care owed by that landowner is to take care to make sure that the visitor is reasonably safe for the purpose for which they've been invited onto the land. The same applies exactly for when people cross land without the owner's express permission, but where he doesn't object to them doing so. So for instance, in the Mourne Mountains, a lot of the access in the Mournes is what we call de facto access, which essentially means the farmers and the landowners turn a blind eye to walkers walking over their land. But the duty of care is exactly the same in that situation as if it was a permissive path. A duty of care to a walker on a public right-of-way is actually less than that of a walker on a permissive path. And the duty of care to a trespasser is also lower than that owed to a visitor. So is the perception out there actually right that there are a lot of claims being made against private landowners as a result of allowing them permissive path access, or otherwise allowing their land to be used for informal open air recreation? Or is there significant evidence of speculative claims being made and settled before the case actually comes to court and compensation being awarded? Well, in 2011, SportNI carried out a study on the impact of the current occupiers' liability legislation. And the findings of that stated that there were no successful liability claims identified in the previous 20 years that related to an injury arising from the informal recreational use of the natural environment. So then in 2017, the SportNI revisited the original study and And this time the review of occupiers' liability claims with respect to outdoor recreation in Northern Ireland again found that whilst there had been claims made throughout the 6-year period, again, none of them had gone to court. So why is Northern Ireland so far behind the rest of the UK in terms of providing access? Well, there's a host of reasons, but some of the more obvious ones include our pattern of rural land ownership. Northern Ireland is dominated by small land holdings, so negotiating access along a 2-kilometre strip, say, could involve 5 to 10 landowners. Also, I've already alluded to it, there's the ongoing concerns and perceptions over occupiers' liability. And thirdly, because our current access legislation is considered not fit for purpose by those working on it on a daily basis. Northern Ireland's access legislation was last reviewed 21 years ago by the Department of the Environment. And back then, the focus of the review was very much based on the potential for creating a right to roam over unenclosed, uncultivated land. In many ways, really what Scotland and England have now put in place. But this was fiercely opposed by the landowning community back in 1999, and consequently it was parked by the Department of the Environment. 21 years later, we are pleased to see that DAERA is reviewing the access legislation, and Graham is going to outline later the thoughts of the National Outdoor Recreation Forum on what any new legislation regarding access to the outdoors should look like. But before he does that, I'm going to pass back to Chris and Mark to talk through some practical access examples.
Okay, so next up is Mark Strong. Mark Strong is from the Coast and Countryside team in Causeway Coast and Glens Borough Council. A presentation from Mark now on asserting public rights of way. Thanks, Mark.
Hi, good morning, everyone. My name is Mark Strong. I'm the Coast and Countryside Officer with Causeway Coast and Glens Borough Council. And this morning I've been asked by ORNI to give a brief presentation on public rights of way in Northern Ireland, including an overview of the assertion process. I should just say, normally I like to include a few colourful slides and pictures in my presentations. Unfortunately, this morning there aren't too many of those. I think there's maybe one card. So apologies about that from the outset. And also, I should just really say that the views that I'll express in this presentation are my own, and they don't necessarily reflect the decision of my employer, Causeway Coast and Glens Borough Council. So in terms of the presentation content, I'll give a brief overview of what constitutes a public right of way. I'll go on to look at Council's statutory duty under the Access to the Countryside Order 1983, especially Article 3, which deals with assertion of public rights of way. I'll also look at how public rights of way come into being, how they're created, and the principles of dedication of common law. And then we'll look at the process of asserting a public right of way, and that'll be the main part of the presentation, really. And finally, a few closing comments regarding public rights of way and outdoor recreation. So, what is a public right of way? Surprisingly, a public right of way, it's actually not defined in the access order. The only thing it does say is that it can't be a road or any other way which is maintainable by a government department. But in common law principles, we know that public rights of way are actually classed as highways. They are used by the public as of right. It's not a given permission by any landowner, but they're used as of right. And it's essentially, it's a legal right to pass and repass along a given line between 2 points. It's not actually a physical entity as such. And public rights of way may be created either specifically or through deemed dedication. And as I've said, they're a permanent legal entity. And you may have heard the maxim that once a highway, always a highway. And that's the case with public rights of way. They remain a highway until they are abandoned or executed by due legal or extinguished, by due legal process. And there are really 3 different categories of public rights of way in Northern Ireland. footpaths, which are used by members of the public on foot, bridle paths, which can be used by horse riders and pedestrians, and then finally carriageway lights, which are used by vehicles, and by horse riders and by. So in terms of council's statutory duty, we look to Article 3 of the Access to the Countryside Northern Ireland Order 1983. Article 3 states that the District Council shall assert, protect and keep open and free from obstruction or encroachment any public right of way. And for this purpose, a District Council may institute proceedings in its own name. Now, interestingly, neither the term assert nor the procedures to be followed are defined in the legislation. And also the term assert, we know, has been judicially interpreted as meaning, in essence, claim there exists. So in terms of how public rights of way come to be and the creation of public rights of way, we look to principles of dedication at common law. And in order for a council to become involved in the assertion process, council must be satisfied that a public right of way exists at common law. And in essence, that involves two factors, that the land and the way must have been dedicated by the landowner, and it also then must have been accepted by the public. That's usually inferred by usage of the pathway by members of the public. Public rights of way be established through deemed or presumed dedication, and that's the usual example in Northern Ireland, whereby by use by the public and the landowner not having really done anything about it, he's deemed to have done the public right of way to the public. And express dedications are very rare indeed. And some of the common law principles are that the route must connect to public places. That's really one of the most important ones. If the written question doesn't connect to public places, well then it can't really be a public right of way, and there's no point in going any further. And the route also must have been used as of right by members of the public. That is, permission not been granted by the landowner. The public's use of the path must have been open, so that the landowner should really have known about it, but didn't do anything to stop the public using it or make clear that he wasn't happy with their using it, and that he didn't intend it to become a public right of way. And that public use must have continued, without interruption, for a specific period of time, without any interruption. And that the users must have followed a more or less consistent line between two places. They just can't wander, as it were, haphazardly over an area of open ground and then claim a public right of way. That doesn't satisfy common law and wouldn't be acceptable. And it's just worth noting that despite sort of common opinion, there is no 20-year rule in Northern Ireland, unlike is the case in England. So in England there is a statutory period of 20 years in regards to public rights of way, but we don't have that in Northern Ireland. Apologies about this next slide. The quality is just a wee bit small, but basically just outlines the process of assertion. And if I just go on to my next slide, it shows you the detail. So we can see in terms of councils getting involved in the assertion process, I suppose it can either really be proactive or reactive. In one sense, council can go out and look to get involved and proactively investigate routes if there are a number of those which could be used for recreation within a given area. For example, maybe within terms of a path network around a village or some project that council with, and they can actively go and look out and search out public rights of way, alleged public rights of way. Or probably the more common way is whereby a member of the public complains that their access rights have been denied by an obstruction by a landowner, whereby the landowner is denying the public the right to use a certain pathway. And that can be a physical obstruction, such as a fence or a gate, but it also can be through signage, and in legal terms, signs dissuading or prohibiting public use can be classed as obstructions in legal terms. So, and currently within our council area, we have a number of investigations which have arisen due to the public having come across signage erected by landowners who've stated that use of a pathway is with their permission or private. Essentially, council will get involved, and it's a process of really lifting evidence both for and against the public right-of-way assertion. And that involves dealing with landowners and also dealing with members of the public who can give evidence, user evidence statements. And that's one of the main ways for the public to give their evidence, and council have a fairly standard, really about a 5 or 6 page, fairly detailed form eliciting information from them about their usage patterns for the path that they've used, and basically the guidance for all of this is really laid out within the Red Book. That's guidelines provided by NIEA to district councils, and essentially council will gather in user evidence, speak to the landowners and give them an opportunity to put their case against the public right-of-way claim. At the same time, council will then be looking for other sources of documentary evidence, mapping or title deeds or aerial photographs, or whatever else may be available. Eventually, council would gather together all the evidence, they would assess the weight of that evidence, and they would then take legal advice. On the basis of that legal advice, council would then be in a position to either show that the evidence supports a public right-of-way assertion, or the evidence shows that there is not a public right-of-way, or it may be inconclusive. And if it shows that there is a public right-of-way, council has a duty to consult the landowner, explain the process, explain the outcome, and if the landowner's in agreement, basically to follow through with an assertion. If the landowner doesn't agree to that, then council may have a duty to proceed to get the resolution vindicated in the county court, and then it's up to the court to decide the outcome of that. And if it's not a public right-of-way, then council will also inform the landowners about the outcome of the case. Just a few closing comments on public rights-of-way and outdoor recreation. It has to be recognised that really public rights-of-way have a fairly limited role in delivering quality outdoor recreation experience. That said, there are still occasions where there are important routes which have to be protected, and council has a statutory duty that they can form part of an overall network of routes, and some of that being by public rights-of-way. Just interestingly, a figure from about 10 years ago, in England, there were roughly 118,000 miles of public rights-of-way. Wales had about 20,600 miles of public rights-of-way, and Northern Ireland, we had 123 miles of public rights-of-way. Now that figure may have gone up slightly since about 10 years ago, but not likely to have risen significantly. So you can just see the complete disparity, I suppose, in one sense, in terms of the number of miles of rights-of-way that we have, and the problem that the legislation. It's a difficult piece of legislation to enact, but that's the outcome, 123 miles. Just in closing, it's important to remember that there's a range of mechanisms that can be used for providing access to the countryside, including public rights-of-way, including permissive path agreements, and other types of public land agreements with public landowners. So in essence, that's the conclusion of my talk. We will have opportunity for further discussion in the breakout rooms, but in the meantime, I just want to thank you for listening.
Great, Mark. Thank you very much, and no apologies needed whatsoever for the lack of flowery photographs or images on your slides. I think it goes with the nature of the topic and nature of the territory we're covering there, but a really clear overview, and I think actually we'll have taken a lot from that for conversation in the breakout rooms later, but also, you know, we'll be able to put that video, we'll be sharing that by Easing tomorrow, and it'll be on the Outdoor Recreation NI YouTube channel as well. So it'll be a really useful tutorial for folk moving forward as well, as we look at public rights of way, as you said, a tricky bit of legislation. Okay, we're doing well with time here. Quite bizarrely now, I'm going to introduce a video of myself. So I was asked to give a quick overview of the Colchicka Cleanish project, which is a Heritage Lottery project that we've been delivering in County Fermanagh. So over to Chris. Hi there. So I've been asked today to give some examples of how Outdoor Recreation Northern Ireland has used permissive path agreements to develop access, primarily for walking trails across Northern Ireland. So we've done that successfully with Urymore and Down District Council, and also with Argent North Down District Council as well. In this scenario, though, I'm going to talk about the Culcutta Cleanish project, which is a project that we're leading down in County Fermanagh. So I'm going to give you a quick overview again of permissive path agreements. I know Karen touched on it earlier in her presentation, but just to capture some of the key points. I'm going to give you some context into the Culcutta Cleanish project, and then give an individual case study then of the Battlefield Trail, the ORNI Community Battlefield Trail, and the Nixon Hall Trail, which are two of the community trails that have progressed to construction stage at the moment. So just to provide you an overview of permissive path agreements, I mean, obviously Carolyn covered this in her presentation earlier, but just to provide a little bit more detail and emphasize some of the key points. As the name suggests, the permissive path agreement is very much agreed with permission of the landowner. So it's a permissive path, it's not a public right of way. It can be used for essentially non-motorised recreation, so walking, cycling, horse riding. In our experience, we've primarily used it for walking, so it'll be interesting in the breakout rooms later to discuss with anybody if they've used it for any of the other forms. It creates linear access, so what I mean by that is it's along a trail as opposed to providing access across an open field or moor or mountain or something like that. But obviously that linear access can turn into a circular walking trail, for example. So I think it's important to say that there is a degree of flexibility therefore within the terms, and those are agreed from the outset. So what term does it last for? Is it 10, 21, 25 years? Again, in our experience, that's typically been the upper end of that. That's often stipulated by the external funder, so the external capital funder, who wants to make sure that they're investing and putting money towards something that's going to last for a considerable period. The permissive path agreement does allow, though, for closures at times on the trail, so it could be a couple of days a year, for example, or it could be for a longer period. The couple of days a year would relate to logistical things like, is the farmer cutting silage, or are they doing some hedge trimming or some other operational reason? But it could be a longer period for ecological reasons, for example, to protect a bird nesting site or something like that. I said the agreement is between the council and the landowner. It's agreed from the outset in principle to allow us move forward in trail design, applying for funding, applying for planning permission, etc. But really it's never really enacted until we're getting to a stage where we want to put the trail on the ground. The council typically will take over the liability of the trail to give the landowner confidence in that, and also therefore they'll take over the management and maintenance of the trail as well. So essentially it becomes a council asset through that permissive path agreement. In the scenario in the Culcutta Cleanish project, actually the council has entered into a service level agreement with the local community group there, and they'll help the council audit and inspect the trail. And they'll also carry out some basic maintenance as well. So just to give you a bit of context then on the Culcutta Cleanish project, this was one of the 4 Great Place Scheme projects that the Heritage Fund funded in Northern Ireland. And we also received match funding then from Ananoma District Council as well. So the total pot was 300,000 across 3 years. And we have been the lead partner in terms of project management, financial admin, drawing down the funding, etc. But it's very much been a partnership approach in terms of the delivery. So the key partners are the Marble Arch Caves UNESCO Global Geopark, Killesher Community Development Association, and Cleanish Community Development Association. And this is the boundary area here then for Culcutta Cleanish. You can see the orange, yellow-orange line there on the map shows the boundary of the area. This is the outskirts of Enniskillen here, so probably by road it's about 7 miles or so southwest of Enniskillen. You'll maybe recognise Marble Arch Caves, Florence Court there with the National Trust, and obviously Culcutta Mountain as well, and the Culcutta Boardwalk, etc. So whilst there's a lot of jewels in that area in terms of outdoor recreation and green space, actually the number of doorstep opportunities for the community to engage with each other and to engage with their green space and to engage with their heritage was fairly limited. So the project hasn't just been about community trails, it's also had a range of projects to allow the community engage, learn and explore their local built, natural and cultural heritage as well. So the community have led on all this. It's obviously not our speciality area at all. So I'd get a snapshot there of underground concerts in the Marble Arch Caves, an opportunity to explore the ORNI River for the first time by canoe, or a community archaeological dig. Our key role in the project, therefore, has been to deliver on the community trail planning aspect. And I think, as the photograph hopefully demonstrates, that's been about people. And the permissive path agreements really only come in at the end to provide a mechanism to that. So you can see in the top slide there, that's members of the local community gathering in workshops to work with our team and identify areas in the area that they like to explore, they like to walk and they like to engage. So they provided us with a broad range of ideas for us to do further feasibility work on. So we actually undertook feasibility work on about 11 different trails, looking at topography, ground conditions, land use, road safety, a whole range of reasons why a trail may or may not happen. But obviously, one of those key elements is a lot of the areas that people were interested in exploring more were on private land. So the bottom photograph then is our community champions. So if Chris Scott from Belfast landed into a farmer's yard in County Fermanagh to negotiate access with that landowner, I may or probably not have got that far. Whereas these community advocates know these people, they go to church with them, they play sport with them, they have a pint with them in the pub, etc., etc. So really, we worked very closely with those community champions, and they were the ones who negotiated the access in principle. Again, the permissive path agreement was only the mechanism to bring that forward. So this is the ORNI Community Battlefield Trail. So this trail is currently in a pre-start stage, and construction will be starting very shortly, which is really exciting, because this will be the first trail that's been brought to reality through the process. So you can see here, this is a 1.8 kilometre trail, and it starts here in a community hub. So this is the community centre, a local school. There's also a childcare facility within there as well. There's a local Gaelic club too, and that's the church you can see there just across the road. So a real community hub which the trail radiates from, and that trail therefore provides access to people's green space, but also to a lovely viewpoint over a key battle site in the area, the Battle of the Ford of the Biscuits. So connecting people to their green space and connecting people to their local heritage as well. But you can see from sort of the background on the map there, the range of landowners involved in making that trail happen. So the orange and green line, orange is where no work's required, and the green line is actually where we're going to build some trail in the area. But you can see there's a community group, there's a primary school, there's a local parish, a whole range of private landowners along the route, and a public landowner as well in terms of NI water. So that'll produce a 1.8 kilometre trail, and we've received funding from that from the National Lottery Heritage Fund and also from DAERA's Environment Challenge Fund as well. But you know, none of that would have been possible had it not been for the goodwill of those landowners and the ability for the council to back the project as well and come on board with the permissive path agreements. It's important to say that in this scenario, none of the landowners asked for or at any stage has money changed hands to make this trail happen. They viewed this as an opportunity to give something back to the community and create a great asset for the local community in their area. So in each of those scenarios, a separate permissive path agreement with each individual landowner has been signed and agreed, which allows us to move forward with those funding applications in confidence that we can deliver the trail on the ground. So that has been, that's been fantastic. So that partnership between council, between landowner, and between ourselves coming in to project manage the piece. Another example then is the Nixon Hall Trail, which is again out for a tender for contractors at the moment. So again, we're getting very close to construction stage there. Again, we've received capital funding for that from the DERA TRIPSI fund, and also with match funding there from council too. So this is the community hub that we talked about there a few minutes ago, and the ORNI Battlefield Trail radiates its way through that area. So across the road then is an opportunity for people to engage with a couple of other bits of built heritage in their area. So Nixon Hall, which is an old domain they can engage with, and also the trail journeys round to Mullinaman Hill. And in layman's terms, that is where the ladies climbed up that hill to view the Battle of the Fort of the Biscuits, which I mentioned earlier. So again, that provides another great community asset in the area. One landowner there, which is quite rare actually for a trail that long, and one permissive path agreement again between the council and between the landowner. But fundamentally, the access was negotiated by the community with a little bit of guidance from ourselves. This is an example here of a permissive path agreement. As you can see, it's 2 pages long. It's not an extensive legal document. Typically, when we provide these, the council drafts these, and we provide these to the landowners. Typically, they do take some legal advice through their solicitor, and feedback from that process has been very minimal. As I said earlier, a lot of the discussion comes around the term, the process for closures. Are there any other terms that the landowner wants to put in? So that becomes a very common sense based, in my perspective, negotiation. As I said, the partners are the council and the private landowner. The term in this scenario is 25 years, and thereafter year on year, with a break period of 6 months. As I said, the councils will manage, maintain, ensure, and inform the visitors of the conditions of access. So we make it very clear to visitors that the access to this trail has been provided through permission with the local landowner. And as I said, that landowner has permission within that permissive path agreement to close the trail, I think in different scenarios for 1 or 2 days. So in summary, the key takeaways from permissive path agreements are fundamentally it's a mechanism, but behind all that, relationships are absolutely key. So in this scenario, it's been a relationship between the community, the landowner, the council, and ourselves. It's very much about permissive access. It's not asserted access. There is a degree of flexibility in approach. And really at the end, that gives everyone assurance. So the funder, the council, the landowner, the local community, and most importantly at the end, really, I suppose, the visitor, that they're going to get a high quality outdoor recreation experience, a high quality opportunity to engage with natural or built heritage in the area. So I hope that was useful. I look forward to further conversation in the breakout rooms slightly later on. Thanks.
Okay, hope that was useful. I didn't listen to any of that. It's almost impossible to listen to your voice back again. So hopefully that was useful. What I should say is that probably the presentation there made the process of community trail development sound really straightforward. Believe you me, it's not. So I was only the presenter there. I just wanted to recognise the real hard work that's done by, first of all, my colleagues, Diane Crooks and Philip Weston, particularly in that project, and also our man in the West, our local coordinator for Calcutta Teenage, Barney Devine, as well, along with many others to make that project happen. So permissive path agreements have been very useful for us, as hopefully the presentation demonstrated, but only because we've been backed really well by those people I've mentioned, and fundamentally by the support of Fermanagh and Omagh District Council as well. Okay, so next we're going to move on to Graham Seymour. Graham Seymour will probably be known to most of you as the chair of the National Outdoor Recreation Forum, or NORF. So Graham's going to join us live.
Okay, thank you. Well, look, thank you for the invitation to speak today as part of this seminar. Very timely, given that the DERA has just started consultation on its review of access legislation. And as Chris has just explained, explain, what I'm presenting are the recommendations that were made by North, the Outdoor Recreation Forum, to DERA when they first announced that they were conducting a review of the legislation which governs outdoor recreation in Northern Ireland. These recommendations were made actually about 2 years ago, and there's been a little bit of tweaking, but basically that it was from that period that we submitted them to them. Firstly, and you could tell from the introductory slide there, we would like to see ideally a standalone outdoor recreation bill rather than the department try to set out to amend the Access to the Countryside Order, which, as others have explained today, dates back from 1983. Now, I have to say that, to my knowledge, DERA hasn't quite yet agreed to this, but neither have they ruled it out. So we keep making the case for this, for a new bill. So what might an outdoor recreation bill look like? Well, these are our recommendations, and you'll see on the slide, but I'll just give a bit more explanation. Firstly, we would like to see a preamble to the bill, setting out what the scope is of the bill, possibly setting out some of the overarching principles on how the legislation should be used in the development of outdoor recreation in Northern Ireland. For example, this might be a good place to state the need for access to be exercised responsibly, and that the primary means of securing access for recreation would be through voluntary agreements. In other words, to set out some principles there that make it abundantly clear to particularly the farming and landowner community that this is not about right to roam. It's very different from that. The bill should include, and it seems logically that it should be somewhere up front, the bill should include a statutory right of access, in our view, to all publicly owned land. As others have commented today, there is now a right of public access on state forest land. We feel that should be extended to all publicly owned land. And I suppose what we had in mind when we were sort of recommending that was the land that's owned by Northern Ireland Water in some of our key recreational landscape areas. Now, there would, of course, obviously need to be exemptions for operational, public safety, security reasons, even conservation and environmental reasons, but the default position would be that public land would have a right of access across it. The next item on our shopping list really was, and it was one that we felt very strongly about, was core path networks. And I confess that when we were making our response, we looked at legislation across, the British Isles, and we borrowed this idea, if I can use that term, from the Scottish access legislation. And as we envisage it, the requirement would be for councils to identify and identify within a time stipulation, not be given forever and ever, to identify and then establish a network of core paths within their areas. And in totality, the network should provide for quality outdoor recreation experience, meeting the needs of walkers, cyclists, horse riders, and of course those also seeking access to inland coastal waters for recreation as well. And we envisage that these core path networks, they would include community trails, like Chris has just been talking about some of those, but also they would include the medium long distance route that the council would identify as being strategically important for their area as well. So there would be a comprehensive network of paths and routes in their areas. The bill should contain clauses to enable councils to enter in permissive path agreements, and Carolyn sort of mentioned in her presentation just how there has been reliance on, now I've written in my slide, Recreation and Youth Services Order, but I think Carolyn got the title right. It's the Education and Youth Services Order. Now, I do know that a lot of people have questioned whether that piece of legislation should be used for permissive paths. Logically, it seems a good opportunity to put it here in an outdoor recreation bill with the other measures to do with access as well. On our fifth on the list, access agreements on open land. Now, we feel that they should be retained from the access to the countryside order, despite, to my knowledge, then they have never been used. In our view, they make a lot of sense, especially in areas where it just would not be possible or desirable to channel sort of recreational users along linear routes. And you can think of, one or two different sort of recreational activities which want access to land, but they wouldn't be walking along a footpath, climbing, for example, hang gliding and other things like that. So you can see where in some cases the access should apply through agreement to an area of open country rather than a linear route. Public rights of way, well, we've heard quite a bit from various speakers this morning about the public rights of way, and the what we would obviously want to see are the clauses for the assertion, the protection, the maintenance of public rights of way should be retained from the present legislation and included within the new bill, but probably with, and hopefully with, some tweaking to make those clauses more user friendly and easier to use. Also, I think we felt it would be helpful if the department would consider other mechanisms for dispute resolution, which avoided potentially costly court cases. Similarly, public path creation orders should also be retained. And again, I don't think they have been used much in the current legislation, but in exceptional circumstances, we think they could be really helpful when all sort of legitimate attempts to reach agreement have failed. And the example that comes to mind, and you can think of one where a council identifies an important strategic route alongside a river. Let's say there's 10 landowners, 9 are in agreement and 1 is being thrown, shall we say. In those circumstances, the council might come to the conclusion that it really does, in the interest of getting that route established, it needs to do a public path creation order. So I think it should be there as part of council's toolkits. And then finally, on the things we wanted to see included, and again, it's been mentioned by Carolyn this morning, we would like to see some clarification on the duty of care, which is owned by landowners to those who use their land for recreational purposes. Now, this would probably involve an amendment to Occupiers Liability legislation. We know there are difficulties here, but we think and we believe that the inclusion of this in the bill would be highly desirable in creating the sort of right environment, the right climate, if you like, for agreeing new access with landowners. So this is just an outline of our proposals. I've had a quick look at the consultation that has just come out from DERA, and it does look like that they have been listening to us. I hope that continues. I hope that North will continue to be able to have a dialogue with the department through the period of consultation, and some of these items which we mentioned will hopefully appear in the new legislation. Okay, thank you very much. I will now pass back to Chris.
Thanks very much. Thanks very much, Graham. That's great. A really good overview of what potentially the opportunities are for us now to contribute to the ongoing consultation. As I said from the outset, we really welcome the opportunity to consult and give opinion on the review of access legislation. So I think Graham's gave a really good overview there of some of the discussion in North and subgroups of North within that. And again, that's the purpose of the breakout rooms following this as well, is to, you may agree with all of that, you may agree with some of it, there may be things that they're not on that list at all on Graham's shopping list. So this is the time to discuss as a sector and discuss as an industry, and see how we can collectively bring that message forward. So thanks, Graham, for summarising that so well. Just a few housekeeping bits and pieces then before we move on to the breakout rooms. As I said, all the outputs from today will be shared to you via eZine tomorrow, and those will point you back to the Outdoor Recreation NI Hub, which is on our website. So you'll find the video outputs and the slides and so on there as well, but you'll also find other useful information. Particularly, many stakeholders from Northern Ireland have engaged with the Outdoor Recreation Network webinars we've been running over the last number of months. So if you've missed those, you can watch those all back again via the hub and access the slides. There's information there around various research reports that have come out, funding opportunities, other news of events and activities taking place in the sector. So I would encourage you to go there and have a look. And also, don't hesitate if there's anything that you want us to share with the sector. Don't hesitate in sending that through to us. You can simply reply to the eZine that's sent out tomorrow to info@outdoorrecreationni.com or Kerry, Kerry @outdoorrecreationni.com, and we'll be glad to share those out amongst the sector. So go and have a look at the hub, and please do share us information so we can share that widely. So we just flick on to the next slide there, please. So just a date for your diary as well. On Wednesday, the 3rd of March, we're going to have the annual Outdoor Recreation NI conference, in which we're also going to launch our new strategy. The strategy has been in draft form now for about a year. We were actually, some of you may remember, we were supposed to launch it last May at Stormont, but obviously events have got in the way. So we're ready to go on that now. So we're going to do our conference, Happy and Healthy Communities and the Impact and Value of Outdoor Recreation. So you can see some of the keynote speakers that have already been secured for that. Professor Shane O'Mara, a really good oracle of the benefits of walking in particular. Aileen from our team will be giving, joined with Duncan Stewart from 56 Degrees Insight, will be giving a really good overview of the current strategic outdoor recreation research that Outdoor Recreation and I have been undertaking. And of course, Dawson will be chairing that. Dawson Stelfox, our chairperson. So put that date in the diary, but more information and more detail to follow in the coming weeks. So do stay connected with us via the website, as I've said. You'll get the eZine again tomorrow. Make sure you are signed up for future eZines. Search Outdoor Recreation NI on the various socials, Twitter, LinkedIn, and YouTube, and you'll be able to keep up to speed with everything we're doing over the coming weeks, months, and years. Just a final word to say a few thank yous. First of all, to our strategic funders who make this webinar and indeed a lot of our work possible, Sport NI and DAERA through the Environment Fund. So thanks to both of them for providing us the resources to provide these training workshops, and again, as I said, other significant parts of our work. Internally, just a quick thanks to the team who have pulled this all together, to Kerry, to Elizabeth, and to Jane, who have made everything work behind the scenes. So thanks very much to those folk. So I think I've covered all the main points there. That's everything for this session. So we're going to close this now and give you a few moments to close this down and click on your link for the breakout rooms, and we'll have some further conversation there. Thanks again to all the speakers who pre-recorded, and Graham again for joining us live. So Carolyn, Mark and Graham, thank you very much indeed for your contributions. Okay folks, see you all in the breakout rooms.